Hello, hello, hello. We're back again. Good evening, everybody. Oh, it's been a minute since I've done a nighttime stream. I don't even know what I'm doing. My goodness. It's good to see everybody. Thank you for being here. Come on in, come on in. All right. So, a jury has been seated in the trial with Sarah Boone. Tomorrow begins opening statements. However, as we're going to learn in the hearing that we're about to watch, there's some unfinished business. I have decided, and I hope you guys aren't too disappointed, but I really want to stream Sarah the opening statements tomorrow. And when we get to the part in this hearing, I will explain why. Uh, it's been the testimony that has come out in Quentin in Leilani Simon's trial with respect to Quentin Simon has been very, very heavy. And while the case against Sarah Boone is heavy, but it's heavy in a different way. And I think I just need a minute. I need a break, I think, from the from the Leilani Simon case. And it doesn't mean that Quentin is not important to me. It doesn't mean that he is not a priority to me. He absolutely is. Justice for him is paramount in my mind. But I know when I've had enough and I feel like I'm at that point where it's starting to I can hear myself being salty. I can hear myself being feisty. I can hear myself lashing out at people, in the chat. And I need a break. So I'm going to do what's best for me. And I'm going to cover the Sarah Boone opening statements tomorrow instead of Leilani. But I will be around, and as soon as I'll probably just cover the morning session or whatever, when they take a break for lunch or whatever in the Boone trial. Then I'll probably just chill out for the rest of the day and recap the rest of it like that evening, Friday evening, because Allie and I still have the calls from Letitia Stout to go through this Saturday. So I want to be fresh with that. And I think that I just need a little moment. So but anyway, that I just wanted to let you guys know that, and I hope you're not terribly disappointed, but I think it's what's necessary for me at this time. All right. So now today there was a hearing. Okay. And it went as, just about as you would expect. Yesterday was also a hearing. And quite frankly, the arguments were just about the same as the arguments from yesterday's testimony and hearing. I mean, I don't understand these attorneys of Sarah Boone's. Give me just a second. I got a little tickle in my throat. Hold on. I don't really understand these attorneys for Sarah Boone. Okay. This isn't a situation where they were appointed. Okay. These people volunteered. Okay. And I like, you knew what you were getting into going into all of this. All right. And so it's like extra annoying to me to hear like complaining about, well, as Your Honor, we've only had X amount of time to prepare. Yeah, but you knew that going in, bruh. Okay. And I feel like, there were times, Mr. Owens, quite frankly, I'm just going to tell you how it is. All right. Um, there were times when I feel like you had poor time management. You knew there was a deadline to file an objection and a motion. You were given a very clear deadline. Hurricane Milton gave you an extension on some of this stuff. And yet here we are, and Helene, and yet here we are, and you didn't file it like you were supposed to, yet you're complaining about things. Then you have your other co-counsel saying, well, guess what? My position on everything, I'm just going to object to every single piece of evidence at all that the state intends on producing. And when it comes my turn to argue about why I think that why I'm objecting to this evidence, I'm just going to tell you, Your Honor, I'm not going to know the relevancy to the case, even though the prosecution has outlined, labeled, and even done it in an order about their case in chief, etc. Right? They've done everything but draw pictures for you. But I don't understand the relevance. I don't know what, if any, relevance there will be. And so I'm just going to object to it all. And then Mr. Owens, when it's his turn to argue, all he does is reread the motion like we're all illiterate. Like, I need you to stop. So I'm frustrated with this whole thing. But excuse me. Here's Sarah's outfit of the day. She's chosen a pale yellow ensemble. All right, so here we go. We're going to get started. All right.
So it would have been Madam Court Reporter due to it taking place during the trial and jury selection. So digital was not providing recording services yesterday. So it would have been Madam Court Reporter. So I would have to beg and plead if she's able to get me a copy of what it was so that it can be re-reviewed so that we're all on the same page for that.
That it started too abruptly. I have no idea what the judge is talking about, so I'm going to have to rewind it. You know me, I like to hear all of the things. I like how Sarah is busy over here shuffling papers. Like she's an attorney at the counselor's table. Oh, this is an unfortunate pause moment. Like she's an attorney at the table rather than the actual defendant, but whatever.
Boone is seated at counsel's table wearing a dark gray suit and a yellow blouse. She is in custody. However, she is not being shackled for the purposes of the trial based on the court's prior findings. We're here to conclude the objections as identified in the state's response to defendant's fifth amended reciprocal discovery exhibit list. The court has reviewed the objections and the defendant's fifth amended reciprocal discovery exhibit list. Anything else we need to address, state, before we begin addressing those objections?
Judge, I do not see a written order from yesterday's rulings on the court's website. I want to make sure I am crystal clear as to what the court has said is going to occur during the trial regarding opening statements by either party and so on and so forth, so that I am not in violation of any motions in limine or any case law that presides over what I can say or not say.
Okay. Madam Clerk. Were you anticipating a written order on the motions in limine?
I felt like I heard you say everything that I anticipated was going to be put at least on court minutes by the clerk's office. I wasn't anticipating to type a written.
Okay, that's what I wanted clarification on. Thank you.
But I just do want crystal clear clarification as to what we are both doing, because based on that, I have some things that I would like to get on the record for post-conviction matters.
Sure. All right. Madam Clerk is pulling up the file now, sir. Give us a moment. You did not. Okay. Madam Clerk has advised that court minutes were not prepared for the ruling from yesterday due to it taking place during the trial and jury selection. So digital was not providing recording services yesterday. So it would have been Madam Court Reporter. So I would have to beg and plead if she's able to get me a copy of what it was so that it can be re-reviewed so that we're all on the same page for that.
Thank you.
Madam Court Reporter, how long do you think that would take you? Is that acceptable? Can we address it at 1:30 before we?
Makes it very difficult to prepare for opening statements when I don't know what I can say.
I agree with you, and I'm not trying to, submarine anybody or put anybody in an inappropriate box,
I
but
understand, but I need to know what I'm going to be allowed to say.
I don't disagree. But is 1:30 acceptable?
No.
Okay, well then, short of taking a break right now and having her create it, I don't know what else to tell you.
Can we finish jury selection? Mr. Henderson's going to take a minute. This afternoon, we start at 10:30 or 11, and that's going to spill into like probably late afternoon before we actually get jury pick. And we just agree on starting opening statements, taking some time, then time, be done.
State?
We have an out-of-state witness and people that are scheduled to come in. So we do see problems with that.
Okay. I don't know how long jury selection is going to take this morning. I can't recall off the top of my head how much time the state said, or the defense said they were going to need for the purposes of their questioning. So, Mr. Henderson, how much time do you think you're going to need, sir?
Hour and a half, 2 times.
Okay.
And then we've got each jurist pause and come forward.
Correct.
I believe we each have 10 strikes.
That's correct.
So that's going to take.
Okay. Mr. J?
I just need that ruling so that with enough time to prepare.
I understand. So the way I see it is we've got a couple of options. We can, and there's no good way to cut this up. One, we can wait on the objections, which I know you do not want to do. Or we can stop now. Madam Clerk, Madam Court Reporter can provide a rough draft of what was ordered yesterday. We could go over it and review it, make sure that we're all on the same page as to what the court's ruling orally was yesterday as to the various motions in limine. Then we can continue with jury selection, or then we can pick up with the objections. I'm amenable to however it is you want to proceed. I understand your concerns of running afoul with a motion in limine. I totally understand that, but it will take her some time to prepare this.
I'm fine with either letting her do that now or letting her do that after we argue this hopefully last pending motion in limine, but prior to getting into jury selection so that I have time to rework what my opening statement will be based on the ruling during Mr. Henderson's voir dire.
Let me then
Oh, I
ask
see
this
what
question.
he's trying to do.
Assuming we get a jury this afternoon, what are the concerns with starting tomorrow morning with?
Okay, so here's the deal. Oh, sorry, I should probably be using my golf voice because the audio is so terrible in here. What Mr. J is concerned about is there were several motions in limine argued yesterday. Mainly, it's around what can be spoken about respective to the battered spouse syndrome, okay, during opening statements. Now, what the judge ruled was he's not going to prohibit, which is what the state asked for. The state asked that the defense not be allowed to bring up battered spouse syndrome during their opening. But the judge said, no, I'm not going to do that. They can bring it up in their opening. However, they cannot introduce any evidence of battered spouse syndrome until Sarah Boone herself takes the stand. So just to recap, that means that unless Sarah hauls her cookies up to that stand and testifies, they're not going to be able to use the battered spouse defense. So obviously, I think it's too late in the game, right, for them to be trying to change a defense tact. So clearly they're going with the battered spouse syndrome. So I think that we can all safely say that Sarah, no malicious Boone, will be taking the stand. So that's what this is about. And what the prosecutor is saying is, look, Mr. Henderson is going to get to do voir dire this afternoon after we have this hearing. And I would like to use my time effectively. And I would like to be working on my opening statement while he is conducting voir dire. So that's all Mr. J is saying. And let me just say this, in Mr. J's defense, he's currently working on other cases too. Okay. And he's coordinating all of this trial with Sarah. All right. And the defense, just a couple of nights prior to the 14th, or it might have even been on the 14th. I read it to you guys yesterday. They filed that motion in limine, and they wanted to use the 550 pages of George Torres's medical records. Well, I mean, the thing about that is that when somebody, if they send something like that big over, if you're going to make, the state filed the motion, if the state is going to file a motion in limine to exclude that evidence, the only way that they can prepare, I hope you're paying attention, Owens, is to actually look and review the 550 pages. So, like it's a lot. It's really happening, James Blonde. Jury selection is over. A jury has been seated, and it is now time for opening statements. This is the one last hearing that they got to wrap up. But tomorrow is opening statements, and your girl is here for it. Here we go.
With openings, is it due to out-of-state witnesses that may be unavailable or because of their schedules?
I feel like if we have time, we should at least get into preliminary instructions and opening statements and use every waking moment we have to not waste these jurors' times until 5 o'clock today.
Okay, all right. Madam Court Reporter, how long do you think it would take you? Is that acceptable as opposed to in print? She could go back and pull back the audio from and re-review it and just provide it to us now? Okay, all right, then we'll take a short recess. Just let us know when you're prepared to give us that ruling, and then we'll go from there. Anything else we need to discuss before we take this brief recess?
No, Your Honor, thank you.
State, or Mr. Owens?
30 minutes? Excuse me? No, not that long. Okay.
How long do you think? 10, 15, 20? Okay, great. All right, we'll be in recess till 9:45. You're talking about the motion in limine regarding anticipation of affirmatively pled intent to use battered spouse syndrome evidence? Fine. Okay, well, that saves me some time then, so I appreciate that. All right, so do you have any objection then, Mr. Henderson, to the granting of the state's motion in limine, which would allow the state to be able to outline in opening statements and present evidence in the state's case in chief in anticipation of the use of the battered spouse syndrome defense at trial? No. All right, motion's granted. All right, we'll be in a brief recess till 9:45. We're off the record. Thank you.
Fantastic. In the interim, Mr. Owens and Mr. Henderson, could you please, for the love of Pete, use your microphones at the defense table for Pete's sake? It's not rocket surgery. All you got to do is switch it on and then speak into it. Here we go. Oh, look at Sarah. She's doing busy work. I'm telling you that, let me just say what I think Sarah's doing. Sarah's going through some of the discovery and highlighting and marking.
We're back on the record.
What's
case number
important.
2020 CF 2603, State of Florida versus Sarah Boone. We get appearances for the state.
Spoiler alert, everything is important. See how she's busy writing
Ms. Boone
important,
is seated at council table
important,
wearing the same clothing from this morning. Ms. Boone,
Everything
a
is
third of your
important.
defense team is not present at the moment. Are you amenable to proceeding without Mr. Beck being here? Okay, thank you very much. Well, that cures itself. Counselor? Thank you. Record reflect that Mr. Beck has just entered the courtroom. All right, courts had the opportunity to review the excerpts from the motion in limine
What
hearing
are
from
you
yesterday.
doing, Mr.
My understanding
Owens?
is both the state and the defense were provided copies of same. Mr. J, is that accurate?
Yes, Your Honor.
Mr. Owens, is that accurate? Okay.
Look at
The
him.
courts reviewed it. Are there any questions with regards to the court's
Just over here, straight on his phone. You can beat that level of Candy Crush at the next recess.
rulings on that motion?
Yes, Your Honor.
Yes, sir.
My understanding is that based on,
Judge, was it emailed to us?
Sure.
I didn't know.
Okay, I got to take a break. Just give me a second.
Madam Clerk.
Let me just say this. You see how Owens was distracted? He's playing, I don't know what he was doing on his phone. Maybe he was playing Candy Crush. I don't know. He looks like a Matchington Mansion guy to me. I don't know. But here it is. Mr. J is about to address the court. And what happens? Here comes Owen, like a bull in a china shop, interrupting. He's so dadgum rude. I can't take it. No charcuterie board, Deborah Miller. No charcuterie board for one Sarah Boone. She big mad. Jojo correctly and astutely is pointing out that their microphone is pointed the wrong way. I think that just about sums up the defense. Just pointed the wrong way. It just sums up the whole thing with the defense. It just pointed the wrong way. The end. Period.
Clerk's providing you a printed copy, sir.
Stop interrupting, Owens. It's rude. Claus, it's good to see you, babe. It's good
Bless
to
you.
see all of you guys. Thank you for being here. I appreciate it very much. If you haven't done so, give your girl a thumbs up, would you please?
Have you had the opportunity to review that excerpt yet, Mr. Owens? All right, go ahead and take a look at it.
No, I'm a little bit behind, Brat. I'm watching this with you guys at the same time because I was watching Leilani Simon's trial. So now I'm like, I haven't seen today's hearing, but yes, I would imagine you're asking me about today because I remember you being here yesterday. Oh my God. Owens, I'm over you, bro. He's clearly not intimidated at all by Sarah Boone. He's all up in her bubble. He's even making her a little bit uncomfortable. It looks like she keeps shifting in her seat. Okay.
Part of your ruling.
All right, Mr. J, you may proceed.
Thank
Sheesh.
you, Judge. We are referring to a rough draft printout that the court reporter made. It's 4 pages of part of your rulings from, there were several motions yesterday, but in this one, it's on page 1, lines 22 through 24. Part of the court's ruling was it's indisputable that an overt act needs to be provided under the Holland case by the Florida Supreme Court prior to battered spouse syndrome evidence coming in. And perhaps the state wasn't clear in its request, and I apologize if I was not in our motion though, but paragraph 24 of the state's motion includes a quote from the Holland case. However, before a defendant may introduce evidence of the victim's character, he must first show that there was an overt act by the victim at or about the time of the incident that reasonably indicated a need for self-defense. Holland versus State, 916 Southern 2nd, 750, page 760 of that opinion, a Florida Supreme Court case from 2005, which was quoting Quintana, Quintana versus State, 452 Southern 2nd, 98, page 100, a Florida first DCA case from 1984, also quoting Williams versus State, 252 Southern 2nd, 243, 246 is the page, Florida fourth DCA, 1971, Reed, REID versus State, 213 Southern 3rd, 1110 at page 1111, Florida fifth DCA, 2017, Rudin versus State, 182 Southern 3rd, 724 at page 726, Florida first DCA, 2015. So what we were asking for is in addition to the battered spouse syndrome expert testimony to not be mentioned prior to an overt act being laid was any evidence of the victim's character, including reputation or prior bad acts. We apologize if that was not clear since the motion is titled the battered spouse syndrome evidence, but the backbone and basis of that battered spouse syndrome is obviously prior bad acts by the victim. So we are seeking a pretrial ruling as well on the admission of prior bad acts, specific bad acts, or reputation evidence of the decedent.
Thank you. Response.
Oh, I can hardly wait for
I just
this.
have one question as to what time? Are we talking about for Dyer? Are we talking about opening statement? At what time are we talking about?
During the testimony in the trial.
That was my takeaway.
Okay.
Okay, let me
That's
just stop
absolutely
you right here.
The motion.
Okay, let me just stop you right here, Mr. Henderson. This is why I have like, Mr. Henderson, I just want to warn you that you are stepping on my last nerve, okay? How is it that I'm sitting over here, 47 years old with a good enough diploma, okay? I did not go to law school, and even I understood that Mr. J is not talking about voir dire. He's never been talking about voir dire. That was explained to you yesterday ad nauseum, that it had nothing to do with jury selection. In fact, the judge spoke to you in what I can only describe as bold, underlined Sharpie, the big black fat Sharpie marker, the one you used to when you were writing on moving boxes. That is, if his speech were a font, that's what it would be. And I understood that. Okay. And here you go, straight out of the gate. Did you even listen to what Mr. J said up at that podium? Were you listening at all, sir? You couldn't have been. I was. He's talking about during the trial. Nobody gives a rat's fat kneecap what you asked those potential jurors at voir dire, as it was explained yesterday. I'm over it, man.
Motion's granted. So the court's going to rely on that specific excerpt in Holland, 916, 7 seconds, 750.
Hold on, let me see what he actually said.
Opening statement. At what time are we talking?
During the testimony in the trial.
That was my takeaway.
Okay. He's absolutely correct.
Okay, then motion's granted. So the court's going to rely on that specific excerpt in Holland, 916, 7 seconds, 750.
Let me just, did he say he's absolutely correct? He's absolutely correct. Was this not this circular argument that took place yesterday for more than 45 minutes? Yes, Jesse Lee, I did do a little body shaming of rats, not just their fat kneecaps, not their whole bodies, just their kneecaps and the big thick, I should have said the big thick Sharpie marker.
0 at pinpoint 760 through 761. Beginning with, as a general rule, evidence of a victim's character is inadmissible to prove actions in conformity with it on a particular occasion, section 90.4041 Florida statutes. However, when a claim of self-defense is raised, a defendant may introduce evidence of a victim's character to establish who the aggressor was, or that the defendant was apprehensive of the victim at the time of the homicide. Internal citations omitted. However, before a defendant may introduce evidence of the victim's character, he must first show that there was an, quote, overt act by the bracket's victim, end bracket, at or about the time of the bracket incident, end bracket, that reasonably indicated a need for bracket self-defense, end bracket, internal citations omitted. That's the standard. So hearing no objection from the defense, the motion will be granted.
Judge, just understand, clear on the record. It's just procedurally correct. Procedurally, before we can put evidence of that, there has to be a claim of self-defense. That has to come from someone, and in this case, we all know that has to come from this guy.
Okay, received and understood. Any other clarifications for the purposes of opening or trial based on the court's oral rulings on the state's motions in limine yesterday?
No, Your Honor. And then the only other thing that we beg of the clerk of the court and the court is just that we can have some written rulings, even if it's just minutes from all the motions that were ruled upon yesterday, at some point, for the record, for the 6 DCA.
Okay.
Yes, ma'am.
All right, thank you. Anything further from the state before we proceed with the objections? Defense.
Judge, yes, just my overall understanding is that the motions and the orders that the court has apply to trial and the organization or the flow of the evidence at trial. Certain things have to be presented before certain witnesses can testify. It has nothing to do with dire nor opening statement.
That is correct, and the court ruled specifically on that yesterday. And that's in the excerpt that was provided to you and your co-counsel. All right, thank you.
And once again,
I also believe part
the 47-year-old woman sitting over here with a good enough diploma understood that the first 72 times it was explained.
of the court's ruling was that the testimony that was proffered, the expected testimony of the defendant that was given to the experts, I believe the court's position was if that is the testimony, then that is not an overt act.
The court's statements yesterday speak for themselves. I'm not going to rehash that matter
Please don't.
today.
Please don't.
Anything else, Mr. J? Anything else, defense? All right, let's proceed with these objections. The court again has had the opportunity to review that Fifth Amended Reciprocal Discovery Exhibit List filed by the defense, I believe back on October the 2nd.
Hey, ATS News and Baby News, soon to be Baby News. I'm so excited. How are you feeling, babe?
Or the 3rd, and the court was provided yesterday the actual exhibit list itself and the state's response and objections to same. There's no need to go over the items for which the state has no objections. So state, I would ask you just to, provide as to the ones that you have objections for, and I have notes with regard to all of them. So you may proceed, sir.
Oh, hold on before he proceeds. I think that Sarah is writing on her legal pad over there. Lack of 5 peppermints, 2 juice boxes, a Pop-Tart, 2 bags of chips, and or cookies or a Pop-Tart makes Sarah go crazy. Yeah. That joke was funnier in my brain. Let me keep going.
By one, I assume?
I think that's the easiest way to go. I know we start with item 1 and then go to 3, 4, et cetera. So we can ping pong it back and forth from there.
All right, regarding item number 1 on the 5th amended reciprocal discovery exhibit list from the defendant, I do not believe we have received those records.
Response from the defense.
Who knows? Because they don't know how to work their microphone. So we won't be able to hear what their response is.
We're referring to 1. 1A is all the state's evidence that you believe you can use. And I labeled that as paragraph 0 in my response. So specifically talking about your paragraph that you labeled 1, certified medical records from Advent Health Orlando, paren, not yet received by the defense, paren. It's not yet received by the state, paren.
The defense has not received those records.
Okay. Motions or the objection is sustained. Moving to 3. Are these the 550 pages that we addressed yesterday?
My belief, and again, none of the exhibits are numbered as they get disclosed to the state. They're not Bates numbered. I do that myself. But what I have and what I believe is states 2 was 81 pages of records regarding treatment by.
I'm not talking about 2. You don't object to 2. Talk about 3.
Well, I do need to talk about 2 now because
Okay.
This morning, after having previously already been given 81 pages of records that purport to be from Winter Park Advent Health regarding treatment of Sarah Boone over a variety of different dates spanning 2018 to 2020. After having received those, reviewed those, and made my decision on not objecting, this morning I was given a thumb drive from the defense, which contained 119 JPEGs rather than a single PDF with 119 pages. A JPEG, for the record, is a digital picture. They were upside down, they were sideways. I got them all formatted. I was able to read them while we were waiting for Madam Court Reporter.
Y'all, can we take a moment to let's just take a moment. Let's just take a moment to recognize and honor Mr. J. Snark at the fact that this man is able to maintain what is to me a sense of humor. That is what Snark is, in my opinion anyway, about all of this. When he could have been sent a PDF file, thing 1 and thing 2 over there at the defense table sent him what's tantamount to 119 screenshots. Upside down, sideways, all manner of things. And expect this is I feel awful. Mr. J, you are in a hostile work environment, sir. This is too much. How are you going to send this man 118 screenshots? You know that's what y'all did. That's what that is. I know what a JPEG is versus a PDF. Come on now. This poor man. Mr. J, when all of this is said and done, I'm going to send you a fruit basket, my dude. I am. I don't know if that's proper or not. Maybe a fruit basket's too forward. Maybe it's too much, but I'm definitely going to send you a thank you card. You're going to be getting a handwritten thank you card. You know, they don't do that anymore. I'm not going to email you. I'm not going to send you a digital gift card. I'm going to take the time to go down to the store, pick out a thank you card with an appropriate thank you, write a handwritten note, and sign my name. I appreciate you, Mr. J, and I appreciate your snark, and somebody ought to tell you that. Today is that day. I am that somebody. Thank you, sir.
They do not appear to be completely the same as what has been previously provided by the defendant in regards to Winter Park's Advent Health treatment of Ms. Boone. So I just want to be clear that now, since the state's response, there has been some sort of change in what those records purport to be. And we are objecting. We are requesting a Richardson hearing regarding the 119 JPEGs that we were provided this morning in regards to defendant's exhibit number 2.
At this point in time, the court is going to proceed with a Richardson hearing. Defense?
Judge, referring to our paragraph 2, the defense discovery exhibit.
Correct. My understanding, based on what Mr. J just provided, and based on his response, is that there were 81 pages provided to the state on or about September 27th, 2024. State had no objection to those. State further identified that this morning a thumb drive of 119 JPEGs evidencing something else was provided. And under the mandates of the 6th District Court of Appeal, based on Young v. State 369 Southern 3rd 1243, I am required to conduct a Richardson hearing. The court is conducting a Richardson hearing at this time.
Judge, the 81 pages that.
The 81 pages are not at issue.
I understand that they were given Sarah Boone from the Advent Health report. The 119 pages, my understanding is we thought we had sent them previously. We realized yesterday or last night that we had not sent them. So we provided those to the state as soon as we were aware that we had not given them.
And what do the 119 pages evidence?
They're medical records from the hospital relating to Sarah Boone over a period of time. So obviously, that's going to be whittled down depending on her testimony and whether or not it will cooperate. Her testimony that she suffered an injury at the hands of George Torres.
I need more specifics than that. I don't have a time frame. I don't have when. I don't have what.
Well, it's going to have to be matched up with the dates that she was injured, which would coincide with the.
But that all goes to the irrelevancy issue. We're conducting a Richardson hearing at this time. So I need to address the inadvertence or willfulness of the discovery. I need to address whether it was trivial or substantial. And if I don't know what's in these 119 pages, it's difficult for the court to determine whether or not this is a trivial or substantial matter. Are these items that were previously produced in the 81 pages? Are they different? Are they different events? Are they different injuries? Are they different things? Moreover, I need to make a determination as to whether this violation had an impact on the ability for the state to properly prepare for trial. Those are the 3 prongs that I need to address.
My understanding is the first 81 pages were medical records of Sarah Boone that we had gotten from one of the previous lawyers that we had sent to the state. The other medical records were those that we had requested directly from the hospital that we got last week or late last week, and we just failed to immediately provide those.
When did you receive them last week?
I'm not sure, Judge. I have to get my secretary, we have to take a break and let me find out from my secretary when we receive it.
Okay, I'm going to continue with the balance of the objections, and we'll circle back on the issue with regard to this objection so that you can provide when, where, how, what.
My staff is
Understood.
texting her.
All right.
So we-
I'll make a note to circle back to this issue. Moving to number 3. Is this the Advent Health Winter Park Jorge not yet received by the defense? State's response reveals a motion in limine was filed regarding this motion. Is that the 550 pages that we addressed yesterday?
Yes, Your Honor, the state still has not received a whittled down exhibit that they plan to introduce at trial.
The court ruled on that yesterday regarding the blood alcohol content records, and the narrative would be admissible.
I'm still waiting for those particular pages to be disclosed to the state.
Okay.
You want the exact pages that those,
Yes,
the VAC and the narrative are on?
that's what's going to be offered into evidence at this point in time.
Judge, we'll work on that right now.
Appreciate it.
I've got staff here in the courtroom that can work on it.
So as with regard to the state's objection to item 3 that was previously ruled upon yesterday, is that the same with regard to the state's objection as to item number 5, certified medical records, Advent Health, Ultimate Springs, George?
I believe so, without being able to tell. Advent Health, it just seems to all come from Altamont Springs, the records. So I believe that is all encompassing, but so we don't have an objection other than the ones previously noted for 3 and 5.
Okay, thank you.
Okay, I was totally talking to you guys while it was muted. I just have to take a moment here to pause for commentary under fair use. Barely Legal Briefs asks the most important question: who brought Pop-Tarts? Barely Legal, I would like to answer thusly. I, in my kitchen at this time, have 2 boxes of Pop-Tarts. One is frosted cinnamon brown sugar, because apparently I am perpetually a toddler. And the other is the strawberry frosted Pop-Tart flavor. Due to the kerfuffle that has arisen from Sarah's request of Pop-Tarts, I cannot bring myself to open either box of those delicious Pop-Tarts. Boone, I blame you. Pop-Tarts should never be in the kitchen in a box unopened, unwanted due to your shenanigans. You have put a black mark on the name Pop-Tarts, Sarah. I hope you're happy. Way to go, Boone. All right, here we go.
Moving now to item number 6, certified medical records, Orange County Jail, not yet received by the defense. I'm assuming they also have not yet been received by the state.
I think, did we address number 4? We went from 3 to 5?
Oh, I apologize. You're correct. 4, certified medical records, Advent Health, Altamont Springs, Sarah, not yet received by the defense. I'm assuming also then state you have not received them.
I believe the only records until this morning that I had was the 81 pages from Winter Park disclosed on September 27th, 2024. If there is something that they have from Advent Health, Altamont Springs, I don't believe I have that.
Defense.
Judge, we have not yet received those records. We had Sarah Boone sign a medical release, and we have sent requests to various medical facilities asking for records, and we're just waiting on a response.
The objection sustained.
Becky, is there another way to eat a Pop-Tart? I don't even know why. I know that they make the edges like that because something has to hold in the tart inside of the pop, but I break them off. They're completely useless. I used to give them to my dog Nestor, but as you guys know, he passed away. So sadly, I have nobody to give my unloved, unwanted Pop-Tart crusts to. It's a sad day at Bendy Lou's house. I'm telling you right now. It's just not. It's all bad news bears. It's all bad news.
Moving to 6. Certified medical records, Orange County Jail, not yet received by the defense. I'm assuming they have not yet been received by the state either.
Last night, after business hours, I received 382 pages of jail records regarding Ms. Boone. Once again, I had to
Thank
spend
you,
my
Bogart.
personal time reviewing these records. Of the 382 pages, probably fewer than 5% refer to her mental health and the psychiatric treatment that gets provided to inmates at the Orange County Jail. The other 95+% of these records is all about physical treatment, COVID tests, things I won't outline here unnecessarily, since I do not believe these records will come in, but all of the things that you would expect a middle-aged inmate to have to go through for the course of 4 years. The state just is having great difficulty understanding what, if any, pages of these records are relevant. On page 135, there's records from part of her intake procedure on February 26th, 2020. On page 137, that's the initial screening when she came into the jail on February 25th, 2020. Page 137 and 138 include this initial intake screening. But from there, we get pretty far removed in time, pretty far removed in relevance. So the state is objecting to the introduction of these records. Even her intake screening on pages 135 through 138, I don't understand the relevancy of it. She indicates panic symptoms. She's semi-cooperative, has poor insight, unrealistic expectations, wants holistic treatment, doesn't like being housed alone.
Back the milk truck up. Back the milk truck up. No truer words were ever spoken in the history of words than describing Sarah Boone as somebody who has poor insight. Further, she wants holistic treatment. Since when, Sarah? This is her intake, y'all. This is right after she got arrested. She was on Xanax. I don't know about y'all. And listen, I'm willing to learn here. I have admitted repeatedly that I have a good enough diploma. For y'all who don't know what that means, that is a GED, y'all. That is a GED. Okay? And so, and when I was in school, while I did make straight A's, even though I only attended class 2 to 3 times a week, if that, sometimes once a week, depended on the week. It is very possible that on the day that substances occurring in nature was discussed, I might have been skipping that day. Okay, I concede that point. So perhaps I missed out on the day when Xanax is something that is found existing in nature. Did I miss that day? Does Xanax, is there a new world order? Does Xanax occur naturally in nature? Did I miss something? Thank you, Chicken Shipe. Yes, I do. Lowered expectations. Yes. Also, I completely left out the part of unrealistic expectations. Again, I don't know who the author of this report is, but they deserve some level of they deserve maybe a statue erected in their honor. I don't know, something. Because lacks insight and unrealistic expectations just sums up Sarah No Malicious Boone. Yikes on bikes. Let's continue.
The screening on 225 goes through alcohol abuse, yes. Type, spirits, not wine. Last used 2/23/20, several times a week. The intake screening also includes a history of violence towards others, yes. So there's no psychiatric treatment records for treatment for trauma. Any of the recognized trauma diagnoses in the DSM-5, PTSD, or any of the other trauma symptoms that can be diagnosed. There's no records of any treatment of that. It's just the anxiety, which, having read the expert depositions, I'm sure you understand that that was pre-existing.
Yes, Tanika's 2 cents. Let's discuss this. Spirits on 2/23/2020, the day of the incident, which we are all here in court watching, suffering along with poor Mr. J here. Spirits, not wine. It's an interesting admission, Sarah Boone. This whole time, she doesn't like to get drunk. So maybe all the denial in that interrogation room had a ring of truth to it. We were just looking at it in the wrong way. Sarah wasn't denying that she's a drinker. She was denying that she drank the wine. Perhaps she didn't drink the wine. Perhaps what she drank, which is what her spirit of choice is, vodka. See? Another example of Sarah, no malicious, and now no snacks, Boone, leaking the truth. Interesting, Sarah. Interesting.
Before the jail. So our objection is we don't understand the relevance of these records. They do not go to her subjective state of mind on February 23rd, 2020. They do not go to help us understand whether somebody in her position was objectively reasonable on February 23rd, 2020. And quite frankly, most of it's just embarrassing and irrelevant. And it would bog the jury down, much like 487 pages of Jorge Torres's records. There's just a lot of COVID screenings and blood test results. And we struggle to see the relevance, Judge.
Thank you. Response?
Judge, it's similar to the state about 10 days ago, sending me over 500 pages.
We addressed that yesterday. It's not germane to the issue.
As soon as I got the medical records, I sent them to the state. He mentions anxiety was pre-existing. No, that's not what their expert, Dr. Werner, opined in her deposition, that the anxiety she may be suffering from at the jail was from being in the jail. So there are questions about that, but generally you get these records, as you know, when you have a forensic psychologist that's trying to evaluate a patient.
What is the relevance of these records? What do COVID tests have to do with anything in this case? What do blood tests have to do with anything in this case? If they don't, then what of these 382 records, 382 pages of records are relevant?
I'm trying to tell you.
Could you tell us
What
today?
specifically is relevant? What page? What date? What document? You're not answering my question, counselor.
I didn't say we were going to introduce these records.
They are listed on your exhibit list. The state is taking the position that these may be sought to be entered into evidence.
I don't intend on introducing these exhibits, this exhibit in evidence. I intend on potentially the doctors, the experts, Dr. Werner, Dr. Harper, to rely rely on these records?
The depositions of all three doctors predate their request for these records. So it's pretty unclear whether any of these experts have already reviewed these records. Now we're going to have to address, when do I get to depose their doctor, Dr. Harper? If she has not reviewed these records yet, when do I get to depose her? Who's going to pay for the expedited costs for the transcripts? What relevance is it to her if she hasn't reviewed these records? They got these records post deposition, post evaluation. The last date that I believe she saw Ms. Boone was September 30th or October 1st. And then we took her deposition either the 1st or the 2nd. So this is also a problem, even if it's just going to be relied upon and not introduced. And I appreciate them letting us know that they don't seek to introduce these records into evidence, because of course, experts can rely on inadmissible evidence if within the course of that area of expertise, it's the type of evidence that's routinely relied upon.
Yes, I'd also like to take this opportunity to thank Mr. Owens for going ahead and sending over all of these pages after the close of business so that Mr. J had to go through these jail records, which I can only imagine are uncomfortable. I've seen jail records. They're not pleasant to read. And now you're saying, well, we don't really intend to introduce them after sending them, not saying that, right? You just sent them over as part of your reciprocal discovery. You're rude, Mr. Owens. Absolutely rude. And also, I don't know if you guys caught this in chat when I typed this because we were all chatting, but I've had enough of Mr. Owens pointing. Mr. Owens, did you not read your client's letters from this year in 2024, where she spoke and ended each letter with 3 pointing back? Perhaps you should reflect on that, sir. Pointing is rude.
But how are these records relied upon if they acquired them after we've done all the depositions? Now, Dr. Harper did say that she relied upon some jail records during her deposition. State didn't have those at the time. I don't know what the date span is of the records that she did review at the time of her deposition. So now we have new issues to confront. And we would like to know whether or not their experts have been provided these new records so that we can address that.
Mr. Owens?
Judge, I don't want to delay the trial. I'll wait. I will not have Dr. Harper review.
So she has not yet reviewed these yet, correct? Okay.
I don't want to get in a situation where we're going to take another deposition. So I'll wait. I will not ask her to review these.
Okay. State with,
That was the only purpose.
okay. So state, understanding that tactical decision and that Dr. Harper is not reviewed and seemingly will not be relying upon these experts, does that cure any concerns that you have?
Yes, sir.
All right.
I mean, the fact that
Then based on counsel's representation, the court's not.
pardon me, Judge Kraynick, the fact that we're even having to have this argument right now at this late stage in the game is absolute buffoonery at this point. If you had no intention on introducing this as evidence, why did you send it as reciprocal discovery? What is occurring upstairs in that noggin of yours, Mr. Owens? Why are you punishing the prosecutor? Okay, Mr. J had nothing to do with your client fucking around for the last almost 5 years with 4 attorneys. Okay, four of them withdrew for conflict, so we can't count those against Sarah. That's not right. And if we're nothing but fair, if we're not fair, we're nothing over here at in the ward case studies. Okay, and you got me speaking in tongues now. You got me speaking all manner of gibberish, Owens, because I'm so dadgum frustrated with you. Why are you punishing the prosecutor? This is a you issue, not the prosecutor.
Going to sustain or overrule the objection, as the defense has identified they are not going to be seeking any of these 382 pages into evidence. Moving now to 8, 9, 10, and 11. There's no issue with regard to the body cam footage, but there is to the police report itself. What is your response to that, Mr. Owens?
Judge, the arrest reports are not listed as evidence in itself, but the reports may be used to refresh the officer's memory if needed during their testimony.
Okay. Does that cure that understanding? Okay. All right. So based on Mr. Owens's representation, as those items will not be sought to be moved into evidence or received into evidence, but only for the purposes of refreshing a recollection, the objection is not sustained nor overruled, as they're not going to be sought to be entered into evidence. Moving to Exhibit 17. No, I'm sorry. 16. 16 is a repeat of 11, so the court's going to adopt its, or similarly with regard to that exhibit. Mr. Owens, are you only going to be seeking the arrest report for the purposes of refreshing?
Yes, sir.
Okay, so court's same ruling with regard to Exhibit 16 as with 9, 10, and 11. Moving to 17, the jail calls involving defendant and third parties. State, anything else to add other than your written objection?
No, Your Honor.
Response?
The defendant is not intending to introduce the jail call.
Okay, the objection is sustained. 18, prior criminal history of George Torres not yet received by the defense. Has the state received that?
Other than the arrest history that has resulted in interaction with the state attorney's office, we have not. He's not a testifying witness. So obviously, we have to provide, if they can't get it through due diligence, rap sheets of witnesses, but he's not a witness. So we have not done anything other than had discussions about prior interactions with the state attorney's office.
Okay. Response, Mr. Owens?
Judge, we're referring to the prior record involving Sarah, that Sarah's aware of.
Okay.
I know he had some priors in Pennsylvania, maybe Massachusetts. We're not referring to those. We're only referring to the ones involving incidents involving Sarah.
I'm just trying to understand, are they seeking to introduce some sort of paper, or is this just the broad notification that Ms. Boone, when she testifies, will be testifying about any prior incident of violence that she wants to regarding the decedent, because you can't rebut it?
What is it? Is this oral testimony? Because this is an exhibit list, so that's my confusion.
We're all confused, Judge Kraynick.
Because if it's oral testimony, that may be a different critter once the overt act is established under Holland.
Judge, she's going to testify to it, and then
I don't know, Tanika. I have no idea what is happening here at all.
ties into that evidence being used to refresh the officer's testimony. The officer's testimony, we believe, is going to cooperate with Sarah Boone's testimony about her injuries, photographs, officer visibly observing injuries on her. That's the nature of this. So I don't think there is going to be anything about a prior criminal history other than what she's testifying to.
Okay, so there's not going to be any documentary or physical evidence that's provided, informations, charging affidavits, a criminal history report, anything tangible that's going to be offered to establish that criminal history other than Ms. Boone's testimony? Is that your position?
Yes, unless there's some dispute about that, that we have to cooperate and ask the court to take some judicial notice that there was a case.
I'd just like to interject something briefly here, Mr. Owens. If you're basing all of this on the testimony of Sarah, no malicious, no snacks, Boone, bruh, your host. Okay? Sarah's already changed her story. The judge put it in writing, for Pete's sakes, that she lacks credibility, and this is the route you've chosen to take. Well, okay.
That she is aware of. That doesn't open the door to hearsay. That doesn't open the door to any of these things that he seems to be referring to, whether it's criminal rap sheets, which is what I believed he was referring to, or police reports, or state attorney records of no bills, or I don't know. Based on his last statement, I don't know what we're talking about now, but we do have hearsay objections to, I thought we were talking about physical exhibits. And that's what our objection would be to believing that what was represented was a criminal rap sheet.
Judge, part of battered spouse syndrome, and Dr. Kraynick would testify, I assume Dr. Hunt will testify about it, Dr. Boone will testify, is this feeling by a victim of being battered that she has nowhere to turn. His family can't help her, she has no group. The state attorney dropped 3 of the charges. 3 separate times George Torres was arrested, charged with violence against Sarah Boone. And her request, she wanted them dropped. That's part of the syndrome. But in addition, in her mind, she felt like the state attorney had let her down. They could not, they dropped 3 of the cases, so she felt helpless that there was some outside entity that would protect her. That ties into her state of mind as to whether or not she felt an imminent threat at the time of this event. So that may become relevant depending on what Dr. Harper says, Dr. Williams says about that, what Dr. Kraynick says about that, as to whether or not she felt helpless because the state attorney's office was not prosecuting George Torres when she was.
But that all sounds like oral testimony. And again, this goes back to, this is an exhibit list. What are the exhibits? Tangible, physical.
We may want to introduce something in a court record indicating that the state attorney dismissed the case.
Okay. What does that have to do with prior criminal history? Because that's the topic here. Prior criminal history of George Torres Jr. not yet received by the defense. That's the line item in your exhibit list.
I will withdraw the prior criminal history.
Okay. All right. So based on counsel's representation of the withdrawal, the court will not sustain or grant the objection. Does that clarify that for you, Mr. J?
Thank you.
All right. Moving now to 19, Orange County Sheriff's Office investigative workup report. Response.
This be used to refresh the officer's memory if need be during their testimony.
Okay. With that understanding, Mr. J?
Yes, I'm not clear what a workup report is, but if it's not sought to be introduced into evidence, then I will accept that representation.
Okay. So accepted. Your objection's overruled based on counsel's representation. The investigative report workup will not be offered into evidence, but merely for refreshing. Moving to 21, all court orders in all Orange County criminal cases regarding George Torres. State. Any further argument?
I believe we went from 19 to 21 without addressing 20.
Oh, I apologize. I had the wrong, I color coded this and I miscolor coded this one.
Introduce anything on 20.
Okay. Then based on counsel's representation of withdrawing that, the court will not rule on that objection. Moving to 21, anything further, because we kind of addressed this as well with number 19. Anything further, argument state.
Okay.
Anything further, argument?
No, sir.
Okay. I'm going to overrule the objection as to as this point in time, because if a declination of prosecution may have been filed, that may be relevant based on Ms. Boone's testimony. So I'm going to overrule your objection at this time, assuming the overt act concept is placed into evidence.
Okay, I want to discuss this overt act business just briefly. According to yesterday's hearing, and I want y'all to brace yourselves, because if you think that you've heard all the poppycock that the defense has to offer up until this point, you ain't seen nothing yet. So just let's all take a moment, harness our cheese, center your chakras, and brace yourselves. The defense is claiming that the overt act committed by George Torres that triggered Sarah was when he stuck his hands out of the suitcase. That's the overt act. That is the overt act that the defense is using to get in battered spouse syndrome. That's it. The overt act that Sarah did, that Sarah says she intentionally did not zip that suitcase all the way up because it was her belief, because she saw him being able to get the two fingers out, that he could get out. Remember, her first story, her only story up until 2 weeks ago, was that this was all just an accident. It was on an accident, Your Honor. Once she saw George's fingers start to poke out of the suitcase, she then proceeded, by her own admission, to get the wooden baseball bat used by her son. Another clear indication she doesn't think about that child. And proceeded to hit his hands and hit the suitcase with that baseball bat. This is her story now. This is ridiculous. And I understand why Kraynick is letting it in, though. I understand he's going to let the jury make the decision, which is probably for the best.
Moving to 22, family law case file, Boone v. Boone, case number 2017 DR 01660.
Okay, this is the part that I came in at, and this is where it's about to get spicy. Here we go.
An O. I understand the state's objection as to relevance and hearsay. Response?
Judge, Brian Boone, the anticipated is going to testify before the state, and he testified for the defense, and he may be considered an adverse witness or hostile witness, and so we may attempt to establish either bias on his part based on some of the documents or orders in court record, or we may reflect, for impeachment purposes, the fact that he has not complied with some of the orders, and that the reason being is because of his feelings for the defendant. He's now got full custody of their son, and has had full custody for 4.5 years. That was not the agreement they originally had, and he was ordered to pay alimony, which he has failed to do as a result of being incarcerated. So there's litigation going on. Brian Boone has counsel, Sarah Boone does not, and that force of their.
What does the non-payment of alimony have to do with what's happening in a family case?
Well, Judge, that goes to his testimony, that goes to his credibility, whether or not he can be impeached, that her in the position that she's in now, he's biased. And to show that he's biased, that he has not paid alimony for, supposed to pay $1,000 a month for a number of years, that he's just failed to comply with the court's order. That shows his personal bias or feelings towards it.
Response?
Sounds like this is ongoing pending litigation that has not been decided by a circuit court judge in the Ninth Circuit Family Division. I can certainly understand why one may believe they don't need to pay alimony when their spouse is incarcerated. I can certainly understand why somebody may believe they don't need to pay child support when their spouse is incarcerated, and they would probably want to seek legal redress about those issues. And it sounds like it's all ongoing.
Are there any orders from the court in that case addressing the non-payment of alimony and that being contemptuous or in violation of any court order?
No, they were divorced. I think there was a marital settlement agreement that was attached to the final order. Brian Boone did open the case back up to move the child to Gainesville, which has happened. And then my understanding is there's still some issues. I think she was given some kind of a notice of the hearing coming up. She's not represented. I don't represent her.
So if there's no order in the court file finding there's a violation of an order to pay alimony, what is?
Well, there's a final order about his obligation to pay alimony. And I think if he gets on the stand, I'm going to ask him, but you haven't paid her alimony like you were ordered to do so. I can go into under cross-examination.
But it sounds like there's pending litigation including a relocation and I don't know because that's not my
That's
case. I
been
haven't looked
decided.
at it.
That's been decided. He hasn't been able to relocate. I don't know all the ramifications. I'll look at the court file. I think we had subpoenaed the custodian of the records of the court file. I'll look at it and I'll let the court know and the state know.
Can you all approach this for a moment?
All right, let me just briefly let me summarize for you in the audience on the live and on the replay just what exactly Mr. Owen's argument is here. Sarah Boone, who was arrested February 25th, 2020, okay, who has resided at the Orange County Detention Center since that day, to use her terms, ongoing for 5 years now, okay? That's her address, where she is provided, as every inmate is provided that resides in a jail across the United States or in prison. She is provided 3 hots and a cot, okay? She leaving their son to be solely taken care of by his father. This petty heifer has the audacity to try to bring up in open court that he hasn't paid her alimony. Now to add insult to injury, prior to her arrest, the 2 phone numbers Sarah dialed the most frequently when she was in a jam was 911 and Brian Boone. Anytime, day or night. We watched last week. We watched the body cam footage from George's arrest in 2019, where Sarah Boone called Brian Boone to come over to her apartment to deliver, to deliver her spare key at almost 2:00 in the I think it was past 2:00 in the morning. It was somewhere between 1 and 2. Regardless, in the middle of the dadgum night, drunkard and Cooter Brown. And now, the person who rescued her frequently, the person who, when she found George in the suitcase, was there, tied his whole day up, had to make arrangements because it was her day to go pick up their son. She couldn't do it, clearly. Got him meleeed and roped into this. Now he's a witness. You want to haul this man into court and demand to know why he hasn't paid his alimony. Owens, Stop listening to your client. Ridiculous. Absolutely ridiculous. I can't even believe this
All right,
is
thank you all
being
both for your
allowed.
arguments and clarifications. Based on, the court's going to overrule the objection at this time for the reasons discussed at sidebar. Moving now to 23, the policies and procedures of the Orange County Sheriff's Office regarding Miranda. Have those been received by you, Mr. Owens?
Yes, sir.
Okay.
I'm no longer seeking to introduce those.
Okay. All right. Based on counsel's representation, court takes no action on the state's objection.
Same with 24.
Based on that representation, court takes no action. Moving to 25, records from Tealwood Park Apartments.
Judge, we never received what we wanted. We're not seeking to introduce that.
Okay. Based on counsel's representation of not seeking to utilize it, court takes no action on that objection. Moving to 27.
26, the defense does not intend to introduce any of the 911 calls.
Okay. All right. Thank you. Moving to 27, the video footage of the arrest on February 25, 2020.
The defense has not received that. The state may have it in their possession. It appears.
Here goes
news
Sarah.
footage, Sarah Boone in handcuffs being escorted.
State, do you have such an item in your possession? News footage?
No? Not that I know of.
All right, but we have not received it, so we don't have the evidence.
Okay. All right. Based on it not being received, court's going to sustain the objection. Moving to 29.
Look at Sarah.
the
Important.
iPhone photo file name. Not going to read it. It's very long.
Judge, I do not intend to introduce 29.
Okay. Court takes no action based on counsel's representation. Moving to
Important.
32,
Sarah's.
iPhone photo.
Owens, I hope you know that all these things that you saying you have no intention to introduce, Sarah is making notes of. This is going to be included in your letter when all of this is said and done. Just know, Owens, you're getting a letter. Congratulations.
Yeah, I'm sorry, sir.
29, what is the ruling?
There is none, as the defense has advised they are not seeking to enter it into evidence. 32, another iPhone photo file name. It's very long, so I'm not going to read it.
Defense does not intend to introduce.
As such, the court will not take any action on that objection. 33, another iPhone photo file name. Court's not going to read it because it is too long.
Defense does not intend to introduce.
Based on counsel's representation, court takes no action on the objection. Moving to 48, another iPhone photo file name, 505 period JPG underscore embedded underscore 1 underscore 772.
We would stipulate.
All right, the objection is sustained based on stipulation. Moving to 59 and 60. I understand your objection, state. Any response?
Hello.
Any and all exhibits previously listed by the state.
Here we go. This is going to be set. Why are
Yes,
you
sir.
bringing your phone? Level 53 on Candy Crush isn't going to help you out right now, bro.
Judge, Mr. J is a smart lawyer with a lot of experience. He's board certified. He's filed this motion.
Yeah, I
in
sped it up,
to
Callie Lisa.
disallow the battered spouse syndrome twice. And yesterday, we were forced to disclose the overt act that constituted our defense that tied in with the self-defense. And so tactically, he was able to get us to that posture. So he knows our defense and how we're coming at it. The problem is the state has not been forced to give the details of what they allege Sarah Boone's overt acts or non-acts.
I need to clarify something. There was no forcing yesterday. The court reviewed Dr. Harper's deposition, and there was no overt act that she had testified to. She was specifically inquired about any imminent fear, and there was no response to those questions. The word overt act did not appear in any of the 4 or 5 sessions that she had with Ms. Boone. And state was seeking, as we addressed yesterday in limine, to prohibit that.
I disagree with that. That was his deposition. He tried to control the witness. He kept cutting her off. He wouldn't let her finish explaining. I certainly wasn't going to do it. She's going to testify in trial about it. It's not my fault that he felt like he got the answer he wanted and he moved on. He didn't ask for any elaboration about that, but that's going to come out. But I understand that's all you had. But we had to do that. The state has not had to do that. And I understand under the 6th Amendment that we have a right, the accused has a right to be informed of the nature and cause of the accusation. And the problem with that boilerplate information is we don't know what they're claiming that she actually did, overt act or omission, that constituted second-degree murder. So because of that, we have to list everything because we don't know. It's like he wants to know. He wants the court to make rulings so that he can tweak his opening statement based on the court. The same with us. We don't know how to respond to their opening until they give it because we don't understand the full nature of what they're alleging Sarah Boone did to constitute second-degree murder. So in an abundance of caution, we've got to list everything that may be relevant, but we don't know yet because we haven't heard. I would like to renew, they've renewed their motion on battered spouse. I would like to renew my motion for a statement of particulars so that I could know, the defense team could know what it is exactly that the state attorney is alleging that Sarah did or did not do that constitutes second-degree murder. It's a serious charge. This is not, it's a unique case. It's not something that happens every day.
Mr. Owens, for the love of Pete, the action that your client took was when she zipped the zipper on the suitcase, recorded herself taunting the victim who was pleading to be let out, telling her that he couldn't breathe, and she continued to mock him, saying things such as, "That's on you. That's my name. Don't wear it out. That's your fault, stupid." Okay? Then she carried her ass up those stairs and proceeded to, on accident, unintentionally, without plan, although she did every single thing that one would do to make themselves prepared for bed and going to sleep, on an accident, she fell asleep. Where George Torres, who was still in the suitcase, was left to die by positional asphyxiation. That is the overt act. I don't know if you need a picture drawn for you. I don't know what it is that you think that you need or that you're entitled to under the Sixth Amendment. But if I can ascertain that information and I don't have a legal degree, you ought to be able to as well. Stop playing games. This is a big fat waste of time. And now you've gotten on my nerves. It's bad enough your client ruined Pop-Tarts.
And that's why we believe that it was proper under that rule of a statement of particulars so that we could be informed about what it is exactly that they claim that she did criminal so that we could prepare a defense. And it goes to directly to this point, which is they want to know why we want these documents and what documents specifically are y'all going to use. Well, it's difficult to tell when we don't know what we're accused of.
Any response, Mr. J?
Yes, sir.
Let me just tell you, what's about to happen is the best thing that I've seen come out of this hearing this whole day, aside from Mr. J's snark, because that just goes without saying. That's enjoyable 25-8. But what he's about to say right here, right now, just absolutely made my day. Here we go. Everybody brace yourselves. Take a sip of water if you need to. This is not, but I would encourage you to stay right here. Don't let it, this is not the time for a potty break. This is not the time to walk the dog. None of that. Sit and just pay attention because this is everything.
Mr. Owens, Mr. Cacciatore, myself, and Dr. Werner all sat together within 5 feet of Sarah Boone the first week of October and heard the final version. It's not very dissimilar from the version of Dr. Harper, but Dr. Werner's deposition was provided to the court previously for our motion in limine. I don't understand the position they're taking that they were forced to show their cards when Dave Cacciatore and myself and Mr. Owens and Dr. Werner were all there together to hear her version. And her version is, it was all fun and games. It was Sunday fun day. He gets into the suitcase. We're all laughing. I zip it shut. We're still laughing. There comes a point in time when he says, "I can't breathe." This triggers her based on her past abuse, no overt act that day. And she begins violently doing the things to the suitcase that she says she did, whacking him with the baseball bat on his fingers. And now, after being the initial aggressor, now after having committed a forcible felony or two, now after having put Mr. Torres in a reasonable fear of death or great bodily harm, she says, well, she realizes now if he gets out after these things that I've done to him, I'm in big trouble. And it's my understanding that we have had this discussion, and that if that is the proffered testimony, that is not going to amount to an overt act, which will allow for reputation evidence, past incidents of violence, or the battered spouse syndrome evidence. That they weren't forced to show their hand. I was there. The rules of criminal procedure allowed me and Mr. Cacciatore to be there and to witness this evaluation. So that being said, we're not abusing the system. We're not doing anything that we're not allowed to do. And we're making every effort to make sure that we understand how this trial is going to go down and how they, and Ms. Boone understands how the trial is going to go down. Because my understanding of how it's going to go down is she's going to have to testify to the specific events of that day. And right up when she comes to the point to saying, and when he said, I can't breathe, the state attorney, Mr. J, is going to object. He's going to ask to approach. He's going to say, Judge, there's been no change in her testimony. Unless there is, then that's a whole different bag of worms. But if there's been no change in her testimony, Judge, we got a ruling prior to this that there's been no overt act testified to. Now we're going to object to her answer of because of the past violence. And we're going to object to any further attempt to bring in prior violence, reputation evidence, or battered spouse evidence. I just want everybody to be clear and on the same page about that. Now, in regards to their request, a renewed request for a statement of particulars, they've had the discovery for several years. This is the state's case. A video that starts at 11:12:45 p.m. on 2/23/2020. Sarah, for everything you've done to me. Sarah, for everything you've done to me. Sarah, F you, laughter. Sarah, F you, laughter. Sarah, stupid. Sarah, that's my name. Don't wear it out. Sarah, I can't effing breathe, baby. Seriously. Yeah, that's what you do when you choke me. Sarah, 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 laughter. Sarah, I can't breathe, babe. Laughter. That's on you. Sarah, I can't breathe. Laughter. That's on you. Sarah, unintelligible, drunken, slurred words. Laughter. Sarah, 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 I can't breathe, baby. That's what I feel like when you cheat on me. Sarah, F you. I can't effing breathe, Sarah. You should probably shut the F up. Sarah, shh. That's our case. That is an evinced, depraved mind, conscious disregard for whether he lives or dies, whether she put him in there or not. She let him remain for 2 minutes during that video. And then at 11:23:03 p.m., there's another 22-second video, and it just zooms in on the suitcase. Sarah. So that is a second-degree murder case when the medical examiner comes in and says, George Torres died from positional asphyxiation and the asphyxiation from being in a confined space. And eventually, after Lord knows how many breaths, he expired in that suitcase when she went upstairs and went to bed. But in addition to those statements, we now have her new statements, which are she intentionally violently shook the suitcase, threw it upside down, hit him with a bat, committed independent forcible felonies. And that's going to be corroborated by the medical examiner's testimony to all the blunt force trauma to both sides of his face and his mouth. That is a second-degree murder case. That is what we're going to be presenting. This is a portion of what I will be telling the jury this afternoon.
Any rebuttal?
I wanted that in writing weeks ago.
Man, sit your ass down. I know he asked you for your rebuttal, but this, remember when I said at the beginning of the live, when we get to the part that made my decision about whether I'm going to stream Sarah Boone or stream Leilani Simon, it was this moment right here. I want to hear Mr. J give the rest of his opening remarks. I wanted it in writing. Sit your ass down, pick up a pen and write it down. That's what you should have done. Hell, it's on Law and Crime. I'm pretty sure Court TV has it. 11 billion other YouTube channels have it. There's a transcript available. Take a picture. Write it down. I don't give a fuck. We wanted it in writing. Get bent.
she was assessed, Sarah Boone, the defendant, was assessed at the Orange County Jail a couple of weeks ago by Dr. Warner. Their rebuttal, state's expert. The characterization that Mr. J just gave about her testimony, I do not agree with. There was 4 of us there. Dr. Werner, 5 of us there. Dr. Werner, Sarah Boone, myself, and the 2 prosecutors. The mistake we made was not recording that assessment. Because I can't testify to what she said. The 2 prosecutors can't testify to what she said. The only 2 people that can testify to what she said is Dr. Werner and Sarah Boone. We dispute their characterization of what she said. That's just going to have to be testified to by Sarah Boone and then Dr. Werner. And jury, while we're here, they are going to have to decide who to believe and what happened. But that is a jury question that we're all going to have to wait for. I appreciate the prosecutor giving me the evidence he intended to introduce to prove second-degree murder. It was something I was asking for a couple of weeks ago. Thank you.
For the same reasons that the court identified when we had the hearing on the original motion for particulars, the court relies on its same ruling in the case law identified at that time. The renewed or tennis motion for a statement of particulars is denied. The state's objections as to paragraph 59 and 60 are also overruled.
Okay, now there are some who think that given what just took place and the things that Owens said right now is going to alter, Sarah's going to change her testimony or tweak it or alter it just slightly. And that comes from the fact that the evaluation given to Sarah at the jail by Dr. Werner was not recorded. So the problem, this is where the issue comes in. Mr. J's, which I believe Mr. J's account of what Sarah said, okay, but it wasn't documented. So there's no way for them being the state, to use that evaluation to impeach her testimony, which is a shame. However, I do think that it's quite possible that Sarah will alter might be too strong. I don't think she's going to completely change her testimony, but I think that she's going to tweak it just enough in her mind. This is Sarah we're talking about, okay? So it doesn't have to make sense, and it won't. It should. If it makes sense to us, we're all host. That's all I'm going to say. I think that she is going to tweak it just enough. Modify. Thank you, James Blonde. That's probably a better word. I think she's going to modify her testimony slightly based on this situation that's occurring. This is what I think is going to happen. I think it doesn't really, at the end of the day, matter a hell of a lot what Sarah says. The proof is in that video. I think that the most damaging evidence that the state has against Sarah Boone are those 2 videos, period. I think that I don't even think the interrogation video is as damning as those 2, what they refer to as the suitcase videos. I cannot, and I think that when Sarah hauls her cookies up to that stand to testify, all I think it's going to do is seal the deal for the jurors. I don't think that there's any level of amount of testimony. No matter how, even if they rose Sigmund Freud from the dead and had him evaluate Sarah and had him testify on Sarah's behalf, I don't even think Dr. Freud could change the jury's minds after they see those 2 videos. That's just how I feel. I think that her trying to say now that George's hand or fingertips coming out of that suitcase was the overt act that triggered her is utter, complete poppycock. I think the jury is going to see right through that. I think the jury is going to see exactly what we see in those two videos. We do not see a scared, intimidated, frightened woman. What we see is an angry woman bent on punishing George Torres for all the wrongs, whether they are real or perceived wrongs, because some of them, we have to be fair. Some of the things that she's likely angry about are actual wrongs, things that he actually did to her. And I think that the new testimony is going to be in direct contrast to what she's always said happened that day, that it was an accident. Now all of a sudden it's self-defense. This is all problematic. It's just about damn time. I'm just glad that all of this is happening. I'm glad that George and his family are finally going to get justice. Sarah, enjoy your power suit and your ability to be unshackled, riding on a legal pad, unfettered. Okay? Have fun while you can, because it's not going to be long. And if you think that Orange County is terrible and made you miserable and caused you anxiety, which if you didn't have anxiety before, then what were you on the Xanax for, ma'am? Last I heard that benzodiazepams are for generalized anxiety disorder. So I don't understand what you would be on, what you would need that for if you didn't already have anxiety. But that's neither here nor there, because whenever you get sent to the big house, Florida prisons are not known for their hospitality. If you think you have, the only thing that might be slightly better in prison than the county jail is maybe the things that you'll be able to, like, you'll have more, you will get yard time and stuff like that. That's about it. Okay, that's it. So enjoy it while you can.
The only other issue to address then is the Richardson violation. Court's going to take a short recess, and we'll address that as promptly as possible. It is 5 till 11. I still intend on moving forward with jury selection this morning. We will be moving to 23, correct?
Yes, sir. I'm just making sure I'm clear on 60. Our request was that prior to the testimony of any of the listed witnesses, which I listed only by initials, that we have the opportunity to depose them and we address the cost of expedited transcripts. And I just want to make sure they meant to overrule that request.
I apologize, because I was just looking at what was articulated in the exhibit list, which was any and all relevant reciprocal discovery to be obtained through ongoing investigative efforts. What's your response, Mr. Owens, with regard to these persons identified in the state's objections who may be called and deposing them?
Well, the state listed a bunch of witnesses on October 3rd. So if the court allows the state to do this and take the depositions, then we ought to be allowed to take the depositions of their witnesses they listed later.
I believe those are the same witnesses that they've listed in regards to the prior incidents. The deputies that went out on the call outs and the cases that resulted in cases in the state attorney's office and 911 dispatchers.
Okay. Is that accurate, Mr. Owens? That October 3 state's list?
I don't know.
But yeah, we don't dispute that they should be allowed to depose them, but they've been listed by both parties, whereas these people are unilaterally listed by the defendant.
Judge, again, I'm not complaining. I've been on the case 45 days as we have gotten witnesses or found witnesses.
I wish I had more time. I wish that I had used my time management skills a little bit better today, because what we really need for this trial is a freaking bingo card. What we should have had for these hearings is a bingo card, and we needed a space for every time Mr. Owens mentions how long he's been on this case, a case that you volunteered to take. You parachuted in here to swoop in and save Sarah Boone.
Billy Lane or whoever else was trying to locate him on my team, we have tried to disclose it. Based on what Sarah Boone has asked us, I want this witness, I want this witness. We've made attempts to comply with her request. Whether or not we're going to call them, the law says, the case law says, you know, Sarah Boone has a right to trial, Sarah Boone has a right to testify, Sarah Boone has a right to appeal. I believe those are the three fundamental.
Yeah. You keep flinging that arm around over there in her general direction, and she's going to have a case against you. You're awfully close to catching her square in the face with that pen, bro.
But the defense lawyer makes the decision about which witnesses to call. So although she may want some witnesses, she's asked us to find them and list them and locate them, which we've done. That doesn't mean that I have to call them. And it may not, we may not call many of those that she wants to, but I believe my right to do that and to present our defense with our witnesses is paramount. And she does not have the right.
Fantastic. Fantastic. You're just admitted in open court in front of God and everybody that Sarah Boone is running your case. But not all the way. You just checked her a little bit and said, ultimately it's up to me. That's why you're finna get a letter.
Thank you. All right, court's going to take a brief recess to address this and the Richardson violations. We'll be in a short recess. Thank you.
All right.
And what specifically was the Richardson violation for then, if it wasn't for number 6? And I apologize.
Number 2 is the 119 new JPEG pages, according to be from Winter Park Advent Health, and they're a little bit different than the 81 pages that I previously received.
Okay. So the ruling remains the same. Court's going to reserve, address the Richardson hearing tomorrow, and you were to provide an edited version of those records that you seek to offer into evidence. Mr. Owens, before 9 a.m. tomorrow morning.
Regarding the paragraph number 2, regarding the winter.
Could you please acknowledge that you heard the judge? You understand what the words that came out of that man's mouth, Mr. Owens? You need to have it pared down before 9 o'clock tomorrow. Okay, 9 a.m. Eastern Standard Time. Not after breakfast, not after CSI, not at 9:01, not at 9:02, before 9 a.m.
Park Advent Health records, the 119 that we gave him this morning.
That is correct, sir. With regard to the witnesses that have been identified
I'm
by the
glad,
defense
Tanika.
in
Glad
paragraph
you guys are
60
enjoying this. I
of the
have
state's
enough
response,
of Boone and Owens.
those witnesses will be excluded if not deposed prior to being called as witnesses, and the defense shall pay for any and all expedited transcripts.
All right, Judge, the same as should apply to them. There were 3 people that they gave us late that we didn't have before: Rachel Fenner, Meredith McCaskill, and Victoria Shelton.
State response?
Meredith McCaskill is an FDLE analyst that is substituting for an analyst that is unavailable during the trial period. So in an effort to not continue the case, we've got a substitute analyst. So that's our reason for the late disclosure on her. And who are the other 2?
Michelle Fenner and Victoria Shelton.
And those are the 911 dispatchers. If we end up having to call them, then that's fine. We will pay for the expedited transcripts. What I would expect will not be lengthy nor expensive.
Okay. Has the FDLE analyst that was originally set to testify been deposed in this matter?
Mr. Cashtor does not believe that the defendant ever deposed that person.
Okay. Any other positions, Mr. Owens? Okay. All right. State will afford the same opportunity to the defense as provided by the state to the defense. Court's going to be in recess. It's 11:27. Hang on. Juror number. Yes, let me address that. Can I have the thing again, please? If you all still have yesterday's sheets from jury selection, Madam Clerk has advised that jury services has told us the juror in seat 25 wearing badge 63 called. Is it child? The nephew that she cares for is ill and that she is not here due to caring for that child. He is not here due to caring for that child. State's response, if any.
For cause.
So stipulated, juror number 25 wearing badge 63 will be struck for cause. We'll advise the jury services to call them and tell them they do not need to report. With regard to the order tennis motion as to Ms. Boone's request for snacks, the order tennis motion is denied. Ms. Boone is being provided all the same services as to any other inmate being transported for the purposes for trial. Anything else we need to address, State, before we report back to 23 at 1 p.m.? Defense?
No, sir.
All right, we'll see you all at 1 p.m. Thank you very much.
Thank you all very much. Thank you, thank you, thank you. That's it, you guys. At the end of the day, the judge said, "No snacks for you." That's what you get, Sarah. No snacks. No snacks today. No snacks tomorrow. No snacks. I'd like exactly KPM. Like they, will pay. Yeah, will pay. The taxpayers will pay. Mr. Owens over here being petty. Well, Your Honor, the state has 3 extra witnesses. One is a substitution, and the other 2 are 911 dispatchers. Did you even do your homework? Owens, do you even Google? Come on, man. Get it together. Oh, you just missed it. Hang on a second. I'll play it again for you. Scott, give me just a second. All right. I'm going to share it one more time. Let's all hear Sarah's. Let's all hear what happened with the snacks together again as a group. Right before I get out of here, get my butt to bed and prepare for opening statements tomorrow. Ready and go.
The order tennis motion is denied. Ms. Boone is being provided all the same services as to any other inmate being transported for the purposes for trial. Anything else we need to address? State. So stipulated. Juror number 25, wearing badge 63, will be struck for cause. We'll advise the jury services to call them and tell them they do not need to report. With regard to the order tennis motion as to Ms. Boone's request for snacks, the order tennis motion is denied. Ms. Boone is being provided all the same services as to any other inmate being transported for the purposes for trial. Anything else we need to address, State, before we report back to 23 at 1 p.m.? Defense?
No, sir.
All right, we'll see you all at 1 p.m. Thank you.
All right, you guys. So there you have it. No snacks for Sarah. And I agree with Neat Noodle. Let's all be petty. Let's all be petty. What we really ought to do if we really wanted to be petty, Sarah loves to receive mail at the jail. We should all take a picture of ourselves with Pop-Tarts or a bag of cookies, 2 packs of chips, 5 peppermints, and 2 juice boxes and send it to Sarah. No snacks for you. All right, you guys. So that is that. I forgot what I have I will schedule the live early in the morning. I need to make a new thumbnail. Oh, thank you for being here, Tanika. I appreciate that. Thank you all for being here. I'll schedule the stream in the morning. Apparently there's going to be a hearing before opening statements start. So just be on the lookout for that. Make sure that you have your notifications set to all, because normally I would do it tonight, but I went live this morning and now I've gone live tonight. And so YouTube will only allow, like, they send notifications out, like you get 2 lives or videos, whatever, in a 24-hour period. And if I schedule that live now, it's before the 24 hours have been up. As long as I schedule the live tomorrow after, like, by 7 o'clock or 7:30, notifications will go out. So there you have it. That it is the Richardson hearing tomorrow, Scott, before opening statements begin. So we will definitely be listening to the opening statements as well as the Richardson hearing. I hope that Mr. Owens understands the use and function of a microphone and chooses to utilize it correctly tomorrow. I don't have high hopes, but I remain cautiously optimistic at this point. What else do I have? Perhaps he goes back at night and watches his performance on the YouTube streets and, reflects upon them. One can only hope. But in the meantime, I want to thank you all for being here. I appreciate the support. If you have not done so, please give your girl a thumbs up on the stream. Give me a thumbs down. Either one. It's up to you. I don't judge. Give me whatever it is you feel that you've earned, or that I've earned, excuse me. Although I will tell you, if you give me a thumbs up, you get a little animation when you do that. I don't think you get anything for a thumbs down. But whatever, takes your chances, roll the dice, whatever you want to do. I appreciate you all being here. I look forward to this trial starting tomorrow. Opening statements right after this Richardson hearing. Be here or be square. I'll see you guys in the morning. Have a great rest of your night. Sleep tight. Don't let the bed bugs bite. Bye.